I believe we have everyone with us for the final case this morning of Gale Force Roofing and ASI Preferred. Um, Obviously, had I not seen Mr. Bell's name there, I might not have recognized him after these years with the full beard. It's been a while. Good to see you again. And we are ready to go. To be sure, is it pronounced like it looks Bailey, or
Yes, Your Honor, it is.
is that not correct?
It is.
Okay. Did you wish to reserve any time?
Yes, Your Honor, if I could reserve the full 5 minutes for rebuttal, please.
Okay. So noted, and you may begin, counsel.
Thank you, Your Honor. May it please the court, Jeremy Bailey, Weber, Crab, and Ween on behalf of Gale Force Roofing and Restoration. The issue in this case is whether the provision in ASI's policy that limits the ability to assign post-loss claim benefits is unenforceable, and it is for 3 reasons. First, it runs contrary to decades of Florida case law and public policy regarding the ability of an insured to freely assign post-loss claim benefits. Second, it's contrary to the Office of Insurance Regulations' specific disapproval of identical policy language for insurers' use in the state of Florida. And third, it does undermine the Florida legislature's reasoned public policy decisions in this arena. Moving to my first point, the policy provision specifically states that no assignment of post-loss claim benefits is valid unless it's signed by every named insured, every additional insured, and every mortgagee. Now, to put that in context, you have to understand where the assignment law has developed since the 1917 decision of West Florida Grocery from the Florida Supreme Court. The idea that a post-loss claim assignment can be limited is a new concept. Typically, the ability to freely assign post-loss claims insurance policies was well understood, and there's decades of case law regarding it.
Mr. Bailey, let me share a concern with you. The West Florida case talks about insurer's consent. And I think it's in the 5th DCA decision that you talk about. There's a direct quote from that case, but there are a few ellipses which explicitly do not include the word that it dealt with the insurer consent. So help me with that problem I have.
Yes, Your Honor. So there's one sentence in West Florida Grocery, and it's a sentence Your Honor identified that the 5th District quotes, that essentially sums up the entire dispute both between the parties here and the split between the 4th and 5th District. And it simply says that for a post-loss claim benefit, the insurer no longer has an interest in those proceeds, so their consent is superfluous after the loss. That's not a direct quote, but that's my summation of it. And the point of West Florida Grocery, I think, to properly understand that sentence and its reliance on the 1905 prior Georgia Supreme Court case was not that it only concerns insurer consent, but it draws the line at when consent can be withheld or when conditions can be placed on the assignment of policy benefits. And that's after the loss. The reason.
But after the loss, I can see why you don't necessarily need the consent of the insurer. But if we look at the policy today, it's not clear to me that it would be inappropriate to require the consent of others who have an interest in how the insurance proceeds are going to be spent.
So 2 points to that, Your Honor. So first is where we draw the line is important because if it is a provision in a policy like this that involves additional insurers, named insurers, mortgage companies, there could be an endless stream of people you could add to that list that would always be changing on what does Florida public policy say about who has to consent to an assignment. If it's a clear line that after the loss, it's a personal property right that the insurer can freely assign, like I believe the case law today says, that's a clear line that is always going to be clear no matter who is also thought of. But the second, all of the other people that are named in that provision, additional insureds, named insureds, and mortgagees, their interests are otherwise provided for in the policy.
Well, that may be true, and maybe it's neither here nor there for your case, but the legislature subsequently spoke about how we're going to deal with these assignments.
And that actually goes to my third point, Your Honor, but I want to go there now because I think that's important. The legislature said specifically that if there is going to be a prohibition on the assignment of post-loss benefits in whole or in part, they can do that, but there has to be two things. One, explicit notice to the insured, right? There's bold paragraphs and specific language that has to be used, and a premium discount has to be given. That was the reasoned judgment of the Florida legislature. They said insurance companies have been talking for a long time about assignment of benefits reform, and they want this reform to be put in place. But if they want to prohibit and effectively stop an insured from being able to freely assign post-loss claim benefits, they've got to give notice to the insured and give them a premium discount in exchange for doing so. Paragraph 18 doesn't do either of those things. It's actually an end run around that so that you can effectively prohibit the assignability of post-loss claim benefits without having to give any special big bold paragraph notice to the insured or providing a premium discount. If this provision was what the Florida legislature has now said is okay to do, and kind of like your waiver form where the insured signs off on it and says, yep, I'm waiving my right to assign post-loss claim benefits in exchange for my insurance premiums to be lower than they were before, we wouldn't be here today. But what this is something completely different. You have a provision in a policy that says you as the insured have the right to receive claim benefits, but we're going to condition your ability to use or transfer those rights on the rights of other people. Other people we don't even specifically describe in the policy. The provision says all named insureds, all additional insureds, and all mortgagees have to consent to it. But there is no definition of an additional insureds in the policy. And that if we're going to try to track and you go through and read the entire policy, there are a number of folks that could fall into that category. But that's not really the point I want to make here today, Your Honor. I do believe the bright line that this court should draw.
But am I correct though? For this particular case, the concern is with the consent of the mortgagee, right? We're not talking about other insureds or named insureds. We're talking about the mortgagee, correct?
Correct, Your Honor. Yes,
And there's no question we know who that is.
Correct. Yes, Your Honor. Just as a point of public policy, I wanted to address the kind of the ambiguity in that provision. But I do think the bright line should be drawn that at the time of the loss, when it's all crystallized, right? And that's what West Florida Grocery said. Prior to the loss, the risk is unbargained for and unimagined. The risk that can be assigned when the policy is assigned pre-loss to other individuals significantly alters what the insurer and the insured bargained for. But after the loss, when it's a crystallized, a finite amount of damage and finite dollar amount, whether the parties agree or eventually a jury decides it, that item right there can be put into a box, and the insurer no longer has any interest in controlling that item. And that's why Florida law, since that point, has specifically required it to be freely assignable, because there is a public policy interest in making sure insurers are able to transfer that freely to whomever they choose. And insurance companies in the state of Florida it's almost as good as the homeowner handing a check to a contractor, because of the ability to know that insurance companies are rated, they're solid, they're going to be collectible. And that idea is what underlays the requirement for post-loss claim benefits to be freely assignable. And I do think it's important to have a clear line drawn, because as the court probably has looked at with the progression of case law, it started with requiring insurer consent, and now it's come to additional insurers and mortgagee consent. If there is no line, and the question is always, well, is it okay for this person to be added, right? Is it okay for this person's consent to be required? It's going to be a never-ending stream of individuals added to that list.
Wouldn't it necessarily be limited to who has an interest in how the claim proceeds are used to ensure that the repairs are made?
If we looked at that provision in isolation, I would agree, Your Honor. But the policy has to be read as a whole, and it has to be read in light of the provisions in the policy regarding the lost payee clause, which specifically says we will only pay to you as all the interests appear in the policy. right? So if your home is damaged and Bank of America is your mortgage company, I'm not getting a check with just my name on it. It's me, my name, and Bank of America. That's specifically what the loss payee clause and the mortgagee clause says. So this idea that we have to protect other people's interests in the proceeds is already done. That would be superfluous in that paragraph when read in conjunction with the entirety of the policy. The point of, and this was the argument that I had with, or I should say the colloquy I had with Judge Ransberger, that the point of paragraph 18 is to effectively cabin the ability of insurers to assign post-loss claim benefits. The idea that it should be drawn at a specific time is the proper place to draw that line so that insureds know what their rights are under the policy, and that it's not going to be constantly changing as insurers come up with new people to add to that list of people. The mortgagers or the mortgagees certainly have a right in the proceeds, but if we're speaking esoterically, additional insureds may not. So an additional insured that's a tenant in a home may not have any interest in the proceeds, but in order for the homeowner to get the assignment to be valid, to get the work done, they have to get the tenant to sign off on it. So there is an idea that additional insureds may not have an interest in the proceeds. And again, to Your Honor's point, that wasn't something raised below or something that we're arguing today, that wasn't the issue. But the argument that we made below was that the purpose of this, or I guess the effect of this provision is to just place additional hurdles in front of an insured in order for them to assign their post-loss claim benefits. The list could be numerous of who is placed there, but the line should be drawn at a specific point in time, and that is when the loss occurs. And that's what in turning to my second point, that is what the OIR said when they reviewed this specific provision on the security first matter. And we quoted the two provisions in our reply brief to show that it is nearly verbatim, if not verbatim, the exact language that ASI and Security First used, that ultimately the 5th District used. And it's important to know that OIR's role here, they're the sole arbiter of what insurance policy language can be used in the state of Florida. But what we have now is OIR saying this type of policy provision cannot be used in the state of Florida, and then the 4th District saying, oh yes, it actually can, where you have a conflict between where you're at in Florida as an insured determines what type of policy language the insurer may use. That is not a workable standard. OIR is the entity that is passed by the legislature in Chapter 20 to be solely responsible for forms, of course, not interpreting forms, right? This court has done that for decades in interpreting policy language and what it means. But approving specific language to be used, that's OIR's job. And in Chapter 627.410 says, if there's policy language that's disapproved by OIR, it shall not be issued or used in the state of Florida. And there's an opinion from the 5th District that's ultimately final now, approving OIR's decision that says this policy language can't be used in the state of Florida. And that,
but they do that. They make those determinations on a case-by-case basis as to policy language is submitted by an insurer, correct?
yes, Your Honor.
And there has been no finding that the language used by the appellee here has been found unlawful or otherwise inappropriate by OIR, correct?
There's been no finding one way or the other, Your Honor. And I
Okay.
believe, as we explained in our brief, there was a point in time where forms were not required to be submitted for approval, and that's where this provision rests. And the plaintiff here is in a position where there's no mechanism to force OIR to review something or to take steps. Certainly if OIR says these words, these 40 words in a row is contrary to Florida public policy and can't be used and issued in the state of Florida, it would be very surprising to me, Your Honor, if they said Security First can't use it, but ASI can. It would seem logical that they would have the same position, and particularly the fact that they litigated this all the way through the 5th District, that OIR is going to take a firm position that this is not policy language that is approved for use in the state of Florida. So, but again, from the plaintiff's perspective, there's no action at law or equity that we can bring to force OIR to issue a disapproval. Our only remedy is when we're in front of this court or the lower court to say it's not enforceable. Look what OIR said about identical language. And and that was the argument that we made to the trial court, that when OIR has disapproved language, because I believe the text of 627.410 is very clear. It says shall not use that language if it's disapproved by the office. So I think that is also dispositive here. Now, if OIR subsequently changes their mind and says the legislature has spoken, we're withdrawing, that's one thing. But to my knowledge, that hasn't happened to date, and that certainly wasn't the case when this was before the trial court with Judge Ramsberger. The point of, and if I can go briefly.
Counsel, I should let you know you're about to butt up at 15.
May I reserve 1 minute for rebuttal, or am I out of time?
No, you're at 15. You get a total of 20. You said to let you know when you got there, so I just did. That's all.
I'll
You can use all of it if you wish.
I'll reserve the remainder for rebuttal. Thank you, Your Honor.
Okay. Sorry for the confusion. Okay.
Good morning. May it please the court. I'm Ken Bell with the Gunster Law Firm on behalf of ASI Preferred Insurance Corporation. Judge LaRose, your questions were exactly on point, and I think the Fourth DCA had the opportunity to review the Security First decision and well points out all the errors and mistakes there. And their summation prior to the conclusion is the contract here does not prohibit assignment. It imposes a condition requiring the approval of all insureds and the mortgagee. We cannot say that this restriction is distinct from the restriction addressed. Excuse me. We cannot say that this restriction, as distinct from the restriction addressed by West Florida Grocery and its progeny, creates some great prejudice to the dominant public interests. And this is sort of what my opposing counsel was trying to argue. And let's be clear, opposing the gale force is not the insured. They're the assignee, and typically an assignee cannot challenge the provisions of the policy, but I'll lay that even one aside. What they don't acknowledge is that the new law, and I provided supplemental authority to that, so the court had also 0.7152 took away the whole impetus for the AOB crisis created by companies like Gale Force before you, and that is they took away the one-way attorney fee provision and required assignees like the parties before you now to go through the same process that insureds have to go through, like the appraisal process and offer settlements, et cetera. And the only fees available are similar to those in 57105 with some additions in that. And that's in subsection 10 of that other section. So yes, the legislature did agree, and as a public policy going forward from July 1 of 2019, insurance companies can restrict assignments in whole, which is contrary to the West Florida Grocery case, or in part, and if they do so, they do have to offer a lower premium. But the main driver of the whole AOB crisis, and if you're not familiar with it, our brief cites to the bill analysis from the Senate in this case. And there was a huge problem throughout your part of the state and the rest of, and I've got the part of, in just water cases alone, the number of cases in 2006 on AOBs was 8. And by 2018, it was 16,800 cases. And if you include windshield glass cases, the AOBs went from 2013 from 6,414 to 34,289 cases out of 278,000 cases filed. And insurers were asking to increase rates because the incentive for companies like this here 2 years after the hurricane, they get a contract while this new law is coming into effect, where they take assignment and they say, we'll take the payment from the insurance company. They're not like the white knights here. They do that. It's not necessary. And that's why I refer to the amicus brief by the Roofers Association. They don't need to take an assignment of the insurance policy. They can do a direct payment authorization. They have lien rights and other rights. So it was an unusual tactic, and it grew and grew and grew and became a social problem, as it's referred to in the Security First OIR decision in the First District Court of Appeal. Judge Makar talks about it, and even on rehearing, they add to the opinion that this is all an issue for the legislature, but Security First in that other case in 2015 was raising the alarm. We need to be able to constrain these assignments because of the one-way attorney's fee provision and these contractors coming in and upping the percentage of their demands by 30 and 40 and 50% and more. So the legislature has addressed it, and that's what unfortunately for us and for you, we had the conflict issue between the fourth and this fifth ECA teed up, fully briefed and ready to be set for oral argument before the Florida Supreme Court. And then a month after this new law comes into effect, they dismiss it. They dismiss the action and don't decide the issue. So any cases that were in the gap in between need to be decided, and that's why it's before you. And I urge you to accept the reasoning of the fourth ECA. West Florida Grocery and its underlying rationale does not apply. This request is not superfluous, and the legislature has addressed the policy. So I think
Mr. Bell, depending on which way we go, do we still need to certify a conflict? Because I guess the Supremes figured the Supremes figured there's no need to look at it in light of the legislative action.
They probably wouldn't accept it as they kicked the last one. But I think, and the prior decision in this court, what was PCA, and so it's not presidential, but it was before a panel. I argued it on behalf of Ark Royal at the time, and the court just PCA'd it because they thought there was no case. And unfortunately, Security First, I wasn't involved in that case at all. There was another decision. Now, as to the OIR claim, damn it. I hope you can see me.
You're still with us.
Okay, we got a robocall. Where was I?
The OIR, I believe.
Oh, the OIR. If you were able to follow legislation, the OIR was right beside the insurance company and everybody else saying this reform needs to be made. And they know of the conflict among the circuits. That's why they couldn't, the DCAs, that's why they couldn't come in and after the fact declare our policy and took no action against my client's policy because the law was in conflict. And unfortunately, again, the Florida Supreme Court did not resolve that conflict. So basically, your decision in this case, if you were to adopt the position of the fourth, and I ask that you don't PC, please write a decision. I think the circuit judges need it below because there's still cases down there, and it will resolve it because, again, you just have this very short window here. The contract was signed in April of 2019 when this act was being adopted by the legislature. A month later, it was signed by the governor, and then they filed suit in August, the month after the act went into effect. So as both Security First and the fifth ECA and the fourth recognized, this dispute and issue is one for the legislature to make. And they extensively, if you look at particularly the limitations on assignments of benefits. Mr. Bailey mentioned the bold lettering. Look at the bold lettering clause that assignees have to put in their contracts because there's extreme consumer protection language in the new law to protect consumers from the abuses of the AOB process. And so again, I think West Florida Grocery and all of the cases afterwards all dealt with insurer consent clauses. None of them ever dealt with a clause like this. The mortgagees have a priority interest, not only a vested interest, but a priority interest. There's a concern of split causes of actions and partial assignments, like in this case, the assignee here did not step into the full shoes and obtain a whole chose or cause of action. He only got the one from Ms. Perez. But Ms. Perez, by her mortgage, had already signed priority interest of that over to the mortgagee. So there's no basis, no reason to extend this policy of West Florida Grocery, that judicial common law policy. There's no reason to extend that to this type of clause because it's not superfluous. It does impact the insurer. The insurance company has duties both to Ms. Perez and to U.S. Bank in this case. So having a policy like this helps the insurance company make sure it does what it's supposed to do under the policy and the mortgage agreements between the parties. And it does not in any way delay the homeowner from being able to get the work done. Because again, like in this case, contract's 2 years after the hurricane. But even if it was an emergency situation, as deemed by the legislature says, no, we'll allow assignments, but they're being abused and you're going to have to go through all of this. And we're going to eliminate the one-way attorney fee provision. And I think that's what will ultimately resolve this, and you won't have the crisis that was developed. Again, solely motivated by the effort to get the one-way attorney fee provision, so you had an uneven playing field between the contractor and the insurance company. Any questions?
Doesn't appear so. You're only halfway through your time.
Well, I know not to talk if you don't need to listen to me anymore. And I appreciate your consideration. I ask that you affirm the trial court's decision, but again, hopefully with just a short written opinion at least.
Understood. Okay. Let me stop the clock from ticking. All right, Mr. Bailey, you have your remaining time at 5.
Thank you, Your Honor. Excuse me, may it please the court. Just briefly, I wanted to touch on what was essentially the third point of my argument, the public policy issues. And I do think that the legislature's decision, and I would ask this court to look specifically at 627.7153, dealing with the change in the law regarding the ability to prohibit in whole or in part the assignment of benefits in a policy, post-loss claim benefits in a policy. 627.7152 is good, and it has the whole fee shifting statute. So if the assignee sues and has to recover a certain percentage for the 627.428 fees to apply, and that's fine as addressing that particular issue. But here, I think what the court should be focused on is this paragraph 18 going to exist following the legislature shift? And I think it will. And I think the rationale that it doesn't actually come out and prohibit anything, right? There's nothing in this policy that says, or in that paragraph that says, the assignment of benefits is prohibited. In practice, it does do that. So I think if this court does not write an opinion that following the 5th district that says this is not a proper way to, or is it improper to limit the freely assignability of insurance proceeds, you're going to have two competing policy provisions. One where some insurers go through the process under 627.7153 and give their insured a premium discount in exchange to prohibit it. And then other insurers who use paragraph 18 where they don't have to do that and they're still able to effectively accomplish the same thing. So I think for that reason, lower courts do need guidance as to—
That's a limited number of policies, is it not? If I'm assuming they renew on a yearly basis.
But Your Honor, it's going to go forward. So there's no provision in the statute that would prohibit paragraph 18 in its current form, because paragraph 18 does not outright prohibit the assignment of policy benefits. I think that's our concern, that if there is not a specific ruling from this court as to paragraph 18's longevity post the statutory change, I do think if Your Honor look at 627.7153, you will not find a provision in there that specifically outlaws what's done in paragraph 18. And you're going to have two competing versions going forward, even after the statutory change, as the policies renew. You're going to have the paragraph 18 defense without the same premium discount given to insurers. And that's our concern. So we would ask that you reverse. We would similarly ask for a written opinion, as there is significant lack of clarity given the split between the circuits or the districts in this circuit. Thank you.
Thank you. Thank you all. Please stay well in these interesting times of ours.
Stay well. Good to see you.
Good to see you. Thank you.